usual, here we meet again this evening, and thank you for those that are joining. Whilst we are at it, those that are joining through Facebook, may I please encourage you to register and join the Zoom webinar directly, because it's easier to manage that way. We still have a lot of spaces. I think we have over 300 spaces that you can still utilize to join the Zoom webinar. I think what I'm going to do is to make the introductions very quickly before I go, then I'll go to Jackie. Is that in this webinar, one CEU point has been allocated. So for all of you that are joining via the Zoom platform, there's very little that you need to do except to stay on until the end of the webinar. My team will then verify you at the end of the webinar sometime this week and next week, and then you will get a letter confirming your CEU for this day. The second thing is, for those of you that want to ask questions, if you are joining us for the first time, please use the Q&A section of the Zoom platform to type in your questions. It may happen that during the presentation, Jackie will see some of the questions and she may address them, but those that are not addressed during the presentations, we will look at them towards the end, and I will then ask Jackie to deal with them one by one. By way of introduction, Jackie has an extensive leadership in legal workflow management experience, managing teams of 300 plus. She has also been involved in designing and implementing legal tech and AI successfully. She heads up Law for All, an alternative legal service provider. If I were to go into the details, Jackie will probably explain a little bit about herself, but basically here is a person who's got good understanding of the law and an application of the law. I think we are blessed in that she also is married to a dentist, so she probably understands our issues better. I'm hoping that the husband has already shared with her some of the issues and she's tried to assist there. So we have someone that is coming from a legal background, a good legal background, and is married to a dentist. So we are in good space today. I do not want to waste time. I would like to go straight over to Jackie, hand over to her and let her talk to us today. Jackie, over to you.
Thank you very much, Casey, and thank you for having me. I don't often do webinars for non-legal people, so it's been a challenge to know in what detail we will go into. Also, as we go along, it's the first time that lawyers themselves have to admit that they are not always certain, because regulations are changing so frequently that it's quite a scramble to keep up to date. What I've done tonight, though, is I've taken the 10 questions that we have received most from our clients, and then also myself as an employer, what my staff are struggling with most. And then obviously being married to a dentist, hearing what his practice is going through and what struggles they are having. So I've kind of condensed it into 10 things I think we should know. As I go through it, please put questions on the side. I'm going to try and manage to answer as I go. Otherwise, as Casey said, we'll tend to them later on. So the first thing that we have to do as we do this is set the stage, just to give a little bit of background before we delve into everything. And that is, what laws should we consider? So I'm not going to bore you too much with the details of the laws, but just to give you an understanding of the scope and complexity of things that matter. We've got the Disaster Management Act that you know by now has been put into place, and it's been extended till the 15th of July. We've got the Compensation for Occupational Injuries and Disease Act, your Basic Conditions of Employment Act, the published government regulations, your Occupational Health and Safety Act. You've got the Labor Relations Act, Unemployment Insurance Act, and so forth and so forth and so forth. It's important to understand that the Disaster Management Act has not done away with any labor law. It's not done away with the Basic Conditions of Employment Act, and it's not done away with your employment contract. So what I would suggest we do, because it's impossible to go through all of those legislations, and to rather, when you look at law or labor law specifically, look at it in terms of the relationship, a tri-party relationship between you as the firm or as the practice, your patients and your staff, and how the different interplay is between these three parties. And all of the legislation and regulation at the moment basically boils down to a few core principles that I think it's a good time for us to just to reflect on that. And that is to ensure trust between you and your staff, to ensure responsibility as someone that is treating the public and paying your staff members, to ensure fairness in all your procedures and protocols, transparency, obviously safety in the time of COVID, and then also realizing that there's a future ahead post-COVID. And these are also there to help you plan post-COVID. So that's just for us to get a brief idea of where we are and what all legislation is at play. The most important thing to start with, though, is the COVID practice plan. Now, on the 4th of June, that was basically Friday, new regulation came out that said every business owner any business that has opened has to put in place a practice plan. Now, this sounds very daunting and scary, and there's so many plans and things that you have to do, but it's actually quite a helpful exercise for any business to do at the moment, because it makes sure that you have checked and ensured safety in all your blind spots. So let's look at what your workplace plan has to entail. Now, this is not something, you don't have to reinvent the wheel, a basic Word document where you just put the different headings up and just make sure that you have considered everything. First of all, you have to set out your opening of the practice, when you opened your practice, how you phased in your practice, what your current operational hours are. You have to put a list of all staff members that have returned to your practice. And with that, you have to list all staff members that have any vulnerabilities. We will get to comorbidities and vulnerabilities a little later on, but you have to, in your plan, indicate that you have already consulted with and identified any staff with comorbidities. Then you also have to just write a little paragraph about what you have done to minimize any staff. Have you looked at your practice manager? Have you looked at your receptionist? Who can work from home? Your accounts manager, all of those things, just to show that you've tried to limit the amount of staff at your practice. Obviously, this is not possible with your nurses, and you need guidance in that. Then you are very lucky with the protocol documents that SADA put out, because you can make reference to your the protocols of SADA as your sectoral guidelines, saying that this plan is in conjunction with the industry standard that SADA published. You also have to put in your daily measures that you are going to do for anyone entering the practice. So that's your temperature checks and your symptom screening for your staff and all your patients. Very importantly, all regulations have asked the business owners and practitioners like yourself to do a lot of staff communication and training. We often think that a lot of COVID is common knowledge, and we don't understand how little information some people still have, and how much misconception there is about the disease. So all of these things in your plan have to be shared with your staff. The plan as it is finished, you have to have a training session with your staff and go through everything that you have considered, why you have done it, and how it will work to put them at rest. And then lastly, what this plan has to entail, which you have to put in place, is who your practice COVID compliance officer is. Now, the COVID compliance officer is going to be the person that's responsible to make sure that all of these protocols are adhered to, and also make sure that it's implemented properly. It's one thing to have a lot of plans and to have all these safety measures in place, but are those actually checked? Because, any control that is not checked might as well not be there. Then lastly, I just want to touch on these two elements, because any business that has less than 10 employees, technically does not need a workplace plan. So many people might tell you that your practice you don't need a practice plan or a COVID plan, but because you are seeing patients, you are open to the public. So you fall under section 42 and 43. So even though you might be smaller than 10 people at your practice, it's still critical for you to put this plan in place. Because as we go further down with any labor problems that might arise, or any civil claims that might come from a patient that might contract COVID at your practice, you want to make sure that you've got yourself covered. Okay, so that's the most important thing that I think we needed to start with. And these are new regulations from the 4th of June. Next up, number 3. Now, this is something that I have heard probably 1,000 times. All the reasons that people are using to refuse to come back to the work. The number one thing is due to a lack of childcare. So as it stands, I've just put this up for those people that don't know when the schools are opening, that you have an idea. We are looking at some grades only going back in August. So that puts tremendous pressure on your staff members. And obviously it puts tremendous pressure on you as well as a practitioner to get your practice operating fully again. So the question is, if one of your staff members has a child at home who can only return in August, is it a valid excuse to not return to work? So technically the law says no, it is not. Childcare is not your responsibility. But this again, as we find ourselves in this time, it's very important to distinguish between the letter of the law and then also a sense of community and humanity. So my advice is to sit with all your staff members who have children, especially those who are single parent households, to see how you can assist them in making plans for childcare or what alternative arrangements you can make for them. Of course, some people take a harder approach and just say, sorry, it's not my baby, it's your baby. I do think that this is an incredibly important time for us to show staff what our culture is and to foster community and to foster a trust relationship between you and your staff members. The second reason for not wanting to come back to work is obviously due to fear. Now, as misinformation spreads and the cases are climbing in South Africa, we've toppled 50,000. Obviously, fear plays a tremendous part, especially to those of our staff members who have to take public transport to get to work. So according to Section 8 of the Occupational Health and Safety Act, it says that if you are ensuring a safe environment and you have taken care of all the protocols, you have looked at all the regulations, and you are doing everything in your power that you can do, fear would not be a valid reason to refrain from coming back to work, and you can force an employee to come back to work. But then again, on Friday, they published a new regulation that says that, in fact, fear could be justified. Section 48 of the regulation states, sorry, I'm going to read some of the law things to you, if you could bear with me. An employee may refuse to perform any work in circumstances arise which, with reasonable justification, appear that the employee to be to a health and safety representative to pose an imminent and serious risk to exposure of COVID-19. So I've highlighted reasonable justification and imminent and serious risk. This is going to be up to the employee to show cause that there is an imminent and serious risk. My opinion of the matter is, if you have followed all the protocols and you have consulted with the industry, with SADA and the protocols they have put in place, you are well in your way to protect employees. And it would be in very rare circumstances that someone would succeed on this. A note of caution, though, when it comes to Section 48 is that the regulation also explicitly states that you cannot punish, you cannot discriminate, you cannot sanction any employee that brings up this section. You have to engage with that employee. And if you are unable to resolve the issue with your employee, you have to consult an arbitrator. You have to go for arbitration to try and solve it. But they are explicit in the fact that you are not allowed to discriminate on the basis of this. So due to fear, our answer is if it's justified. The next big reason why people do not want to come back to work is obviously due to comorbidities. As we've seen with the cases climbing, we see that comorbidities are the greatest risk in where people are suffering. So technically, yes, if someone has a comorbidity, I'm going to go into a little bit more detail on comorbidities and what is the right here. So high-risk employees are any employees that have any of the following symptoms. So this is what the law regards as vulnerable or high risk. It's people with moderate or severe asthma, chronic lung disease, serious heart conditions, immune compromise, severe obesity, diabetes, chronic kidney disease, liver disease, or 60 people that are over 60. Previously, it was a little bit ambiguous, and it seemed that any person falling within this risk group was not allowed to come back to work. But with the latest regulations, they've cleared up this ambiguity somewhat, and they've stated that these people are allowed to come back to work. It's just the employer's responsibility to make sure that their extra safety precautions have been taken into account. So my advice again here is to engage with your staff once you've identified who has any comorbidities or is vulnerable. Do a risk assessment with them and what they would need to come back to work if they are unable to perform their duties from home. If they are unable to perform their duties from home and there's also no agreement between you and your staff member on what would be deemed safe enough for them to return to work, obviously you can go ahead with UIF, which we will look at later on as well. Right. So now we get to, I'm going through this quite quickly. We'll get to all the questions in a bit. So when we look at our practice, you have to ask, I know many of you have suffered tremendously due to the lockdown. The South African economy is shrinking by the expected 17%. So the financial matters are also of, a real concern. So many people have implemented pay cuts. When you do implement a pay cut, you've got to remember that it forms part of the Labour Relations Act, and you can't suspend with any of the Labour Relations Law or the basic conditions of employment. And the two most important things when you touch on labour law is substantive and procedural fairness. Now, these are just fancy lawyer ways of saying you've got to have a good reason and you've got to follow the right procedure. When you do a pay cut, it's critical that you remember employment is not a unilateral contract. In other words, you can make no change to an employment contract that you have in place without mutual agreement. So you cannot cut a salary if staff member has not agreed to it. You cannot change working hours. You can do nothing of that unless your staff members agree to that. When you do a pay cut, you've got to specify whether it's temporary or permanent. You've also got to say on what criteria are you basing it on. This is a great way, again, for communication in your practice to make sure that your staff know what the practice is going through, what your reality is, what your income stream has suffered, and what your expected future holds so that they can also have some certainty. And then, of course, you have to ask yourself is, have you put it in writing? And has the staff member signed to it? I hamper on staff a lot in this because from all the cases we deal with, this, I've seen it to be the most critical element to it is how you as a practice and a community have gotten together, because staff can be incredibly understanding if they are included in the process, if they feel that they have been taken into account, if they feel that you have trusted them in the journey, you have shared your concerns, and you have opened it up that they are able to share their concerns as well. It ensures greater buy-in in the long term. It keeps labor law cases far away, which is in your benefit. So when you do pay cuts, it's critical to think of things. How do you support your staff with information? How do you help them do some financial planning? There's been great relief from banks, the interest rate. So many avenues are open to staff, but what are you doing to assist them if you have cut their salaries? When salary cuts are not enough and your practice has suffered a little bit more and you are faced with retrenchment, we are again in the ambit of the Labour Relations Act. We are looking at substantive and procedural fairness again. Remember, that is having a valid reason for whatever you are doing and you are following process. So the holy grail of the Labour Relations Act when it comes to retrenchment is Section 189. Section 189 puts out exactly what you have to do. You don't actually even need a lawyer. You can just download the act. It is so clearly put out on what you need to follow. In brief, though, I'm just going to touch on a few things. And that is, if you are initiating a retrenchment, you have to remember that a retrenchment is not final unless you have consulted with your staff members. So to initiate the consultation, you have to let your staff members know that you are considering retrenchment and you invite them into a consultation process, which is a mutual problem-seeking exercise where you are looking at all alternatives and you are exploring what your options are. You would put the reasons for the retrenchment, which at the moment would be operational reasons due to loss of income, uncertainty about what the future might hold. I know many of you are struggling with protocols at the moment and how many patients you can fit into a day with all your safety measures that you've had to implement. So your income stream might look different in the months to come. You're going to, in your retrenchment notice, put out what selection criteria you're going to use. The most common one that people use is a term called LIFO, which means last in, first out. When you are doing this, remember, you can't just go the last person appointed gets retrenched. You've got to look at it on job level. So say, for instance, you have 2 nurses. You'll look at in the job category where you are retrenching. If you are retrenching on support staff, that is its own specific job category. When you do a retrenchment, the severance package according to the law is 1 week per year worked, and then obviously the notice period that is due in terms of the labor or the employment contract, and then any leave that is still due and payable to the employee. But as we are in this uncertainty, and also as a country, we are looking at a possible 50% unemployment rate at the end of COVID. So a retrenchment is a pretty tough moral thing at the moment. That's why there is an option of temporary layoff instead of a retrenchment for the time, because we don't know what's going to happen. You don't know what your practice might face in 2 or 3 months from now if you are able to stay open. A temporary layoff means that the employment contract is suspended indefinitely. So the employee is not fired, they are not dismissed, they are not retrenched. The employment contract is still in force, but it is suspended for a time being until you are up and running again, or you can bring it back to life. That means you have to pay no severance package, and you also pay no more salary to that employee. They will then rely on this COVID-19 TERS relief fund, which we will look at in a moment. And if your suspension of the employment contract is longer than 3 months, it will go over to UIF, to an unemployment insurance fund claim. Once you have more certainty on your practice and you need your staff to come back, or a certain class of staff, you can bring them all back. Alternatively, if a few months down the line you realize your practice has been hit harder than you expected and you simply you can't see it going forward, you can then initiate an retrenchment process with the staff members who have been suspended. Okay, so now we're going to look at UIF and the TERS fund. I'm sure many of you know this by now because we've all become kind of lawyers in this time, having to keep up to date with all the legislation and the application process and everything. So we've learned a lot, I think, everyone. UIF as you know, is the Unemployment Insurance Fund, and then TERS is the Temporary Employee Relief Scheme. There was a TERS fund, or the TERS fund was actually initiated way before COVID in 2019 to help employers, but when COVID came, they created a special COVID-19 Temporary Employee Relief Scheme. The thing that you have to know about these two funds is, although you can kind of use either one, it is advisable at the moment to use the COVID-19 TERS fund if you apply for any relief for your employees. UIF is still available, obviously, but TERS has been placed there specifically for the time being, and they've done really well. Their payout times are remarkable. They've speeded up. They're continuously improving. The government has to be commended on that. So far, $16.5 billion billion rand has been paid out on the TERS relief fund. So you can only apply to one. It's not like a lottery where you can put in claims to both and hope both pay you out. You have to pick which one, and everyone advises at the moment to do the TERS fund because it is easier. Their process times are quicker. In the past, or in the last few weeks, it was up to the employer to do the claim with the TERS fund. This has changed due to some, let's not say corruption, but some ill administration of funds on many employers, where they did get the money, but they didn't disperse it to their employees. So now employees can directly claim for the TERS fund as well. Basically, anyone that contributed to the UIF can claim. On Friday, though, they did make a new regulation that said that if your employer never registered you for UIF, you are eligible to claim for the TERS fund. So that would be any of your staff members, if for some or other reason you never registered them for UIF, they would still be able to get some relief from TERS if they apply on their own. An important thing to know about the TERS fund, however, is that they look at a capped salary. So there was a lot of misunderstanding, and people thought that the maximum amount that you can be paid out from TERS is 17,712 Rand. But in fact, that is the maximum salary portion that they cap. And then they do a sliding scale of 38 to 60% on a salary. So 38% is for your highest earners, and to the highest earning cap is 17,712 Rand. So that means the most money that you can get from the TERS fund on a month basis is 6,731 Rand. So you can see there on the presentation, I've put in brackets that the minimum amount is 3,500 that can be applied for, and the max that you can get out is 6,731. It's important to note also that you can't try and jippo the fund to get your staff more money. In other words, if you are paying them, if you did a pay cut and you are paying them, say 5,000 Rand per month of their 10,000 Rand salary, and they put in a claim of lost income, and you continue to pay them, that in the end, they can't earn more per month than they would have in a normal circumstance. Also, due to April, there was some misadministration from some companies. It's important to note that the money can be used for nothing else but paying salaries. There's a link there that I've put. The UIF website or TERS fund website is really very user-friendly. All the forms are listed there. You don't need a lawyer to do this. It's a very simple, basic procedure to follow. Okay. A very interesting question that also arises is that of leave. Now, during lockdown, many of us gave our staff, we used our annual leave for the lockdown days. What they have now come out with is said that, normal leave is still governed by the Basic Conditions of Employment Act, and you get your 15 days if you are a full-time employee. But if you took annual leave during the shutdown, you are able to now go back and claim from the TERS fund for lost income. And then you can do either one of two things. You can credit that leave back to your staff. So say, for instance, a staff member took 10 days of their annual leave, and you now claim that from the TERS fund and they reimburse you. You as the practice can keep that money if you credit your staff back with the 10 days leave. Okay, so it's a way for practices to get a little bit more funding in, because the TERS fund wasn't fully operational when lockdown just started. So retrospectively, you can correct that and give your staff leave later on in the year. Very important though, because there's going to be a lot of audits into this, and a lot of there could be a lot of discrepancies. So your record keeping of payments to your staff, advances you've given them, loans that you've given them, leave that have been credited or moved, you have to keep a very clear record of it for any audit that might come from the department. Okay, now let us move on to the million-dollar question of what do we do when a staff member tests positive for COVID? Again, lucky with the SADA protocol document that you do have, it sets out so many safety precautions that practices have to take that it actually goes far and beyond what the law says to many business owners. So your safety precautions are top-notch. So when an employee comes to work and they present with problems, you've got two options. Either they won't be allowed into the workplace. This will be part of your practice plan that we spoke about at the beginning. So you will disallow them from coming into the practice. These employees will isolate at home. They will be able to take sick leave in terms of the Basic Conditions of Employment Act. If their leave has been exhausted, remember leave works in a 3-year cycle, so some staff members might have already used up all their leave. So if it is, they can claim from the illness benefit under TERS for the 14-day quarantine. If they can show that they contracted COVID during practice, or at the practice there's some other connection that they can prove, you can assist them with a claim from COIDA, which is the Compensation for Occupational Injuries and Disease Act. So anyone that contracts at the workplace can claim money from that fund, and you can help them with that. When someone has cleared their 14 days and they have done their isolation, they are obviously cleared by a medical professional to come back to work. They are allowed to come back to the practice and given them as wear a surgical mask for 21 days after they have been diagnosed, and you've got to closely monitor their symptoms. The question now is, do you close your practice or not when a staff member presents with COVID? The law is quite interesting in this regard because there's no definitive yes. This again becomes a moral question that you will have to ask yourself. If someone presents with symptoms, you obviously have to follow the National Institute for Communicable Diseases on the tracing efforts that you have to do and determine what risk the employee posed, which area the employee worked at. So that will determine whether you have to close the whole practice or are you closing just a specific portion, how many of your other staff members did they get into contact with, and very importantly, which patients did they get into contact with. That will determine what you are going to do. If it's a high-risk case, obviously you're going to close your practice, you're going to sanitize it, and you are going to send everyone to get tested and to make sure that you are clear before you allow patients back into your practice. If it is a low-risk instance where it's a staff member that is not in contact with many of your staff members, that's not in contact with any of your patients, your protocol might change a little bit, that you would just disinfect the area where the specific employee was, and you won't close the practice in total. When someone presents with COVID, it is critical that you contact the Department of Labor and inform them that one of your staff members have presented with COVID, to keep record of it. And obviously you will follow what the National Institute of Communicable Diseases advises you to do. Okay. Then I've gone through this very quickly, so I think we're going to have nice time for questions. The last thing is, what happens if someone gets COVID from your practice? Now, again, we look at Section 8 of the Occupational Health and Safety Act. If you have done everything in your power to ensure a safe working environment, if you have followed all the regulations, your workplace plan is in place, you have control measures, everything is in order, and you have adhered to your industry-specific protocols of SADA, you have done all that you can do, and no one can claim anything from you, because you cannot do more. I'm going to put this, I've used a few very fancy animations just to draw highlight to it. It is critical that all of this is recorded in writing, because any claim that comes out at the end, you are going to have to disprove either in the labor court, either at the CCMA, or if it is a patient that contracted COVID from your practice, it could be a civil case, and the law of delict will apply to that. So when you look at the law of delict, obviously you're going to look at negligence, at intent, and if you have shown you have taken every safety precaution that you could possibly do from a professional point of view, you would not be at fault, not to staff members and not to patients. Okay, so I have given you a labor crash course of note in my allocated 40 minutes that I had. So we can look at some of the questions that we have on here to.
This is from Casey.
Okay.
Jackie?
Okay. Sorry, I just got a note. I just got note that Casey lost his internet, so I must do the question.
I am back.
Oh,
I am
back. Okay. Okay.
No,
okay.
Yeah, I think let me just address a few questions that I've seen that are more administrative. Any of you that were waiting to do the test for the other webinars that you were attending via YouTube or Facebook, the questions are available, have been available for a week and a half now on our website. You just need to go in there and you will be able to download the question, answer the question, and follow the instructions that is on those questions. So I think hopefully that will address. If you are here, you do not need to write the questions. The second question that was asked, yes, the presentation as you have seen it in the slides is going to be made available on the website tonight. So if for whatever reason you've come in late or you want to go and review certain things that has been said, please go onto our website, and in about an hour's time, you will be able to rewatch this particular webinar. So I was a bit disconnected at one stage, and I see that I have lost maybe about 8 questions before 7:30. So Jackie, if you can see the Q&A, I would suggest that you start with a few questions up until around 7:30, and I will take it from there.
Okay. What happens if I only see enough patients to stay open half the day? Can I cut my employees' working hours and salaries? Absolutely. It's a great idea when you are cutting salaries to also cut work hours. It feels very fair to staff. Again, you can't do this unilaterally. you have to do it in consultation with your staff. Explain to them what your position is, and that if you don't do these measures, you might be forced to close down. So your proposal is to cut, say, Fridays and Thursdays or certain hours, and this is how much of their salary you will cut, and let them sign an addendum to their employment contract. This doesn't have to be a fancy addendum. It can really just be something that you typed out to say, starting here, starting on the 1st of July or whenever, this is what we have agreed, and everyone signs that. And that can be a permanent arrangement as well. What happens if my cash flow dries up and I can't afford to buy PPEs for my assistant anymore? Must I close down? And yeah, that's a very tough question, because unfortunately in your profession, PPEs are critical to function. So I think it also becomes very important to look at your cash flow or to look at your practice as a whole, and look at what other operational things you can cut. Obviously, you can cut salaries to afford PPEs. You can look at any other thing in your practice that you can cut, but you won't be able to practice without PPEs, and you won't be able to, all your staff members as well have to be given PPEs free of charge. Since nobody can be forced to disclose their medical history, how do you accommodate it in the COVID-19 plan? That's a very interesting question, because COVID has posed a lot of privacy regulations for us, with the cell phone tracking, and even just sharing your COVID status is by law actually not something you have to do. But under the Disaster Management Act, unfortunately or fortunately, it is something that has to be shared, because it is a state of disaster. So suddenly your right to privacy is trumped by the battle to beat COVID. So although they might not disclose their full medical history, and they don't have to go into details with it, they do have to tell you if they have a comorbidity, and share with you what they would need you to do to accommodate their safety at the practice. If they don't share their comorbidities with you, or any of the vulnerabilities that they face, it is not your responsibility, because it was their choice not to share it with you. And that means that they will come into practice and practice like everyone else. And if something happens to them, it is at their risk and not at your risk. Again, in writing, that you have consulted with staff, that you have done a questionnaire, and that you have tried to identify vulnerable employees. If my assistant doesn't return because she has a child at home, I can't work, do I still then pay her a salary? If she can't come in because of her child, and she says she can't make any other arrangement, remember, it's not a valid reason to stay at home. So you can then tell her that you can temporarily suspend her contract and help her to claim UIF while you get a temporary assistant. Again, engage with her and see what you can do to make a plan for her childcare, and how you can get around it by a temporary staff member, or assisting her to get someone to help her look after her child. But remember what we went through, it is not a valid reason not to come back to work. Another one from Anonymous, my question regarding leave. Let's say my practice gets a positive case and we have to go into self-quarantine for 21 days. If the staff's normal and sick leave is depleted, what do I have to do when regarding the leave? Unpaid leave will upset them. Okay, if you are in quarantine, whether you have tested positive or not, you can claim from the UIF. So if your sick leave is exhausted, you would be able to claim from UIF in that instance. You also don't, interestingly, need a medical certificate to claim from UIF. So if you are self-isolating because you came into contact with someone that had COVID, or someone else at the practice have, and you have decided to all do 14 days of isolation, you will just write up a notice between you as the employer and the staff member, saying that this is the facts of the case, and that you are placing yourself under isolation and no one will be earning an income, and you can send that into a claim for the UIF. Good evening. Does a staff member have only one kidney functioning between 70 to 80% counts as a comorbidity? well, I'm not a medical doctor, I'm a lawyer, but according to the regulations, it seems that any kidney disease or kidney problems would constitute as a comorbidity. Next question, what steps need to be taken in case of redundancy of staff member? I'm not entirely sure what you mean. I would assume it's staff members that you don't need at the moment anymore. In that case, you would go into a retrenchment process. If it is just a temporary redundancy, you would do the temporary layoff, as we discussed, which suspends their contract, which means you don't have to pay them any entitlements. But as soon as you are able to again, they can come back to work. If you believe that it's going to be a long-term redundancy because you've restructured your practice, you've changed the way that you've operated, you are scaling down, then a Section 189 retrenchment process would be advisable. What about locum dentists that only work for commission, no work, no pay? What financial rights do they have? I think that's been one of the most hardly felt is all freelance workers, locums, because there's no UIF contributions, that they have not been able to apply for UIF. With the latest regulation that was published on Friday, though, it says that even people that were not registered for UIF could claim, and there has been some sector-specific things where they've looked at freelancers and they've looked at artists and they've looked at those things. I have not yet seen something specific for locums. But it would be wise to approach the TERS 19 fund under the UIF and to approach them to see what you can do. There's nothing specific though yet for locums. If temperature checks and screening are done at the entrance of the hospital or clinic where you practice, should you do it again at your office? It's advisable if you are the owner of your practice, you want to show everyone that came into your practice is safe. So my advice would be to do it, because you have to record, for yourself. You have no control over what the hospital or the clinic where you practice has done. So if they have made an error or they have slipped up in any way, that could severely affect you down the line. So a word of caution from me would be, even if it does annoy patients maybe to do it twice, is in this instance to rather be safe than sorry. Should labor laws supersede a pandemic? I think they would work in balance. I think we have to always make sure that labor laws are adhered to. These are very trying times, and I think our staff members, remember, whatever you are feeling and whatever your practice is going through, so your staff members are, your neighbors are, everyone is feeling it equally. So we have to put in every measure that we can to make sure that staff members are, or that the workers of our nation are not being prejudiced. I have seen some horrific things that employers have done in the last few weeks. I think it's a time to build culture for you as a practice instead of the opposite. Some people have really used this to kind of kill down labor laws and do terrible things to their staff in survival. So I think they have to be in balance. Lance asks us, can retrenched staff member be employed part-time going forward, pay staff member per day? Absolutely. This is again a time to negotiate with your staff. If you are retrenching a staff member, it is important when you start employing again to offer that position to all members that you have retrenched in the preceding few months. So if you are going to open a half-day post or just a temporary assistance, even if it's just a few hours per day, you would obviously want to give it to any person that was in your employ. On that note, though, maybe a good idea is to not retrench them, but to rather just change their contract and completely minimize their working hours and cut their salary accordingly. So then you don't have to pay out a severance package and re-employ them, but you can rather just change change the nature of your employment contract, if of course they agree to it. Until when will the UIF TERS fund will be able to assist with salaries? From what we know at the moment, the TERS fund is running till the end of June. Remember, once the TERS fund ends, UIF will provide everything that TERS fund is providing at the moment. The application process is just a little bit different. The TERS fund was for a temporary solution, for a 3-month solution while we were in lockdown. Obviously, the remnants of COVID and lockdown is going to last way past June. So I suspect they are going to extend the TERS fund, but that remains to be seen. As we know now, it is just till the end of June. Okay, Anonymous asks, can you be forced to sign a new contract purely to be benefit of the employing dentist by threatening with retrenchment if not signing? Also, can the payslip be withheld? What can you do if this is the case? That screams of unfair labor practice. And remember, all the courts have opened up again. The CCMA is open again. So you can never be threatened if you are not willing to sign the proposal by the employee. You do not have to sign it. They can go forward with the retrenchment process, but they can't use it as a threat. As soon as it becomes a threatening situation where they are kind of forcing you into something, it becomes unfair labor practice, and you can take the matter to the CCMA where they will adjudicate on it and make a finding. But no one can force you to do anything. It's a process to find a solution for both parties, you know. So if the employer acts in the best interest, staff members will follow suit. In this instance, it seems that it is not in the best interest, so I would advise in that instance to go to the CCMA. How long do they assist employers? I would imagine that is what we've just answered, till the end of June, and then after that, the UIF. If a staff member refuses to attend work because of fear of comorbidity, does the practice put the person on sick leave, or does no work, no pay apply? If it is a justified fear of coming to work and they are unable to do their work, they can use all the leave that they have at their disposal. If that leave runs out, then it would be a no work, no pay, and you can assist with UIF in that instance. Can I add balance to give staff full salary? Yes, you can. I assume that's if they have applied from the UIF and you want to top it up, you are allowed to, as long as it's not more than they would normally earn. So no one can profiteer out of this, and no one can make more money out of it than they should. Can you have your staff sign an indemnity that they can't sue you for contracting COVID at work if you have a minimum safety measures in place? You can, but I doubt that it would hold up in law. Because if you have, regardless of what you have signed, if they contracted at your practice, it becomes a civil claim. The law of delict comes into play, and you can't contract out of the law. So if your safety measures are in place, you have nothing to fear. An indemnity form won't stand up in the end of the day if your measures don't meet the needs. If an employee has 2 employers at different practices and has reached the limit with the first employer, can their second employer still lodge a claim? Yes, remember the limit is per person, not for the whole practice. So every employee can put in a claim for the TERS fund. It's an employee and employer fund. So it is to supplement the employee's salary. So if you have 2 people, both of them can apply. Another anonymous, how does one treat an employee that has been working on a per hour contract? Can you limit the hours, or if necessary, how do you end the contract notice period? Yes, you will give, if you want to end the contract, follow the notice period in the contract, or you can change the hours of the agreement.
Yeah. Let me just help you from here. I see
Okay.
we've got about 43 questions to go through, so I hope that we will be able to finish.
Can I get some wine?
Yeah. Anyway, so let me just help. So the next question is, can an employer apply to TERS for an employee if they are still employed but over 65? In other words, over the retirement age?
Absolutely. As long as you are still working, you can apply for it.
Thank you. If staff are paid, can the practice still claim from UIF or TERS? I suppose if the staff are paid in full.
Yes, they can. Remember, you can claim for loss of income as an employer. So you can. In that instance, it would look like you have given an advance to your staff, and the money being paid from the TERS fund you will use because you have paid them already. So it will supplement the funds you have already given. Again, keep record of everything.
Can you still apply for TERS if you are back at work but have cut down on the hours of work?
Yes. Any loss of income, any loss of working hours, you can apply for.
So Dr. Anonymous says, it is very clear with these totally one-sided labor regulations, any smart dentist should have closed down immediately. The longer you stay open, the more your problems become, and the more you open yourself to litigation. It is a comment or a remark. How would an employee prove that she picked up COVID-19 at my practice? It is scientifically not possible.
I agree with you, but the law says that it is possible. I think it's going to be impossible to prove that causal connection. I suppose it would be where a colleague had it and probably trying to draw a connection like that.
I suppose what the members should be more concerned about is to make sure that they have done everything possible to protect themselves and staff and patients from the spread. But other than that, as we say, it's going to be very difficult.
Absolutely.
As I'm a commission earner, my income has been affected during this period. However, I'm not registered for UIF. Am I still allowed to claim from TERS? What is the process involved?
There's a lot of ambiguity, so I won't be able to answer you when it comes to freelancers and commission earners, because technically UIF is not paid to anyone that earns commissions. So technically no, but there has been some, it seems that the regulation is taking this into consideration because they've allowed for freelancers. So I would assume very soon they are going to give some leeway to commission earners and any temporary staff like that. I would suggest that you call the UIF office or send them an email. Their response rate is quite good and they would be able to advise you of what to do.
Thank you. Dr. Kutsia says, great lecture. Thank you very much. And then Dr. Naidu, please clarify if the employees had been on short time and we paid accordingly, and now we receive UIF, suppose TERS funds, do we just top up their salary amount?
Yes, you can just top it up.
What is the use of testing? People are more infectious because they test positive. You can test negative today and be positive tomorrow.
This is true. Absolutely.
And then Dr. Pinero says, thank you, excellent presentation, very informative. Welcome, Doc. Dr. Borat, does the employee accrue leave if they are not working during lockdown and still getting paid by TERS?
Yes, of course. If they have not put in leave and they're working from home, their leave cycle remains as is. The shutdown has done nothing to the basic conditions of employment and what leave entitlement someone has. Okay,
I think the follow-up question to that is, if the person is, what they're alluding to, if we have cut down on hours, are they still able to accrue a full leave period during that time?
Well, you'll have to work out if they have cut down to less than the 5 days that they normally work, you'll have to go rework out what their leave criteria would be. So leave usually accrues for every 17 full days, you get 1 annual day. So you'll have to go do they can't lose any leave that they had already accrued. Going forward, if they are working less, the accrual of that leave will change according to the hours that they are now working.
Okay, thank you so much. We are now at 8 o'clock. I'm going to allow another 15 minutes. Please, we've got 41 questions. Do not add any further questions. If you do, we will try and respond to those questions, but afterwards, and then make them available alongside this presentation. I think this is just a comment. It is not possible to prove where an employee may have picked up COVID-19. I like what this doctor says. There is no virus with an ID for Sandton and one for Soweto. I attended many webinars on Zoom, but have not received any communication regarding to the allocated CPT points. Doc, that's Dr. Rob. You will be, if you have not received the communication, it is still coming your way. What we have decided to do, because we are about to change into a new system, we are not going to be sending certificates, but you should be getting between now and Tuesday next week, you will be getting a letter that confirms that you did attend and your CEU, but the certificates will only be delivered to everyone after the new system. But if it does happen that you are audited by Sars, you must please make contact with us and we'll be able to do a manual certificate during that time. Thank you for that question. It's actually a very good question that many people might not be aware of. So let me repeat, you are not going to get any certificates for now until we move to the new system in the next 3 to 4 weeks. But should you be audited by Sars, contact us and we'll be able to produce a certificate. What you will get in the next few days is a confirmation letter of your attendance and your CEU that will be allocated to you. Dr. Mohammed, is culpable homicide murder charge a legal possibility for dentists if a patient dies from COVID-19 and the family claims that it was contracted at your practice? And under what circumstances will this apply?
If you yourself or any one of your nurses has COVID and knows that you have COVID and are fully aware of your status and you continue to practice, in such an instance, it would be attempted murder if they contract COVID from you. If you are unaware of the fact that you are COVID positive and they contracted from you, it's not at your fault. So no claim can be instituted against you. It will only be a criminal case if you knew that you were positive. Otherwise, they might try to institute a civil claim. But again, if you have shown that you have taken all the safety precautions into place, they won't succeed.
Thank you. Dr. Jamuna, are all these applicable to both public and private sector, these regulations?
Yes, it is applicable to the whole country, except for a few, the mining industry, a few very, very specific sectors.
I'm part of a team of dentists working on a commission basis of 40% as indicated in the contract of employment. Practice closed down for 2 weeks during lockdown with loss of income. To recoup the income, the owner has decided to cut some of our clinical code percentage to 20% instead of the 40%, resulting in a significant loss in income without any prior consultation or agreement with staff. I think the question they wanted to ask, is this legitimate? Is this proper?
Sorry, you have to repeat yourself. Sorry, you were breaking up a little, Casey. I'm sorry.
Okay, so basically in this case, a doctor is working as a commission-based doctor.
Okay.
The agreement is that they get 40%, if I see this, 40% of every procedure that they have done. In this case, because of loss of income, the employer then reduced their commission to 20% of the work done. And I think the question is without consultation or agreement with the staff.
That would not stand in law because you cannot change you can't change any contract without a mutual agreement. So they can't change the terms of commission or percentage that they have paid you if you have not agreed to it. So you have a right to claim your full 40% or negotiate, mediate with them, and see what resolve you can get.
I think the big issue is everything is possible, but with consultation.
Absolutely.
Yeah. Is the employer obliged to pay for COVID tests of employees? In other words, who is responsible for this testing of employees? And it's a question that has been asked a few times.
The employer would not be responsible for the test. I mean, obviously, it would be wonderful if the employer can pay for it, and I think many employers are paying for it, because if the person tests and they are negative, they can come back to work, so you're not losing a set of hands or a set of brain. But it is technically not the employer's responsibility to pay for it.
Dr. Singh says, is the burden placed upon the practitioner to prove that a patient did or did not contract the virus at the practice, assuming you are following the guidelines recommended by SADA?
No, the onus would be on the person who institutes the claim.
Then Dr. Cochrane says, we are seeing less lines and that equals less income. If I have 2 dental assistants, may I place one on temporary layoff or must I rotate them?
You can use any criteria you can. In that instance, I would use the LIFO criteria and say that the person that whichever came last, you put on temporary layoff until such time as you need 2 nurses again.
So LIFO or LIFO is last in?
First out.
First out. That's basically the process.
Mm-hmm.
Can you deny treatment to a patient you suspect of being positive for COVID-19?
Yes, because you don't have to allow them into your practice, and it is a dental procedure. It is not a life-saving procedure that you have to perform.
This is a follow-up on the question on 40% and 20%. What is the recourse for the person that feels that they have been unfairly treated in this case?
In that instance, it is a consultant agreement. It's not an employment agreement, so you would not go to the CCMA. I would start with a letter of demand to the clinic or the organization, claiming the loss of income or the discrepancy between, and if not, I would institute a civil claim for the loss of commission.
Of course, I always, from my side, not being a legal person, being a lay person, that everything that involves legal claims and money, the first process will be to try and negotiate to come to some sort of a settlement without spending money. Only when that fails can you then go the legal route.
Especially because our courts are so backlogged, so you want to get things out of court and settle them.
Yeah, but also we must also know that sometimes the legal processes, which is a right and you should follow if you need to, but it can also has its own consequences in that relationships are broken. All of those things you need to consider first. So yeah, if you can settle before you go to court, you save yourself money and possibly relationships. I was paid TERS for April, May. TERS appeared easy as I just had to select the month of May to be paid. Hope this was correct. I tried calling that number that has been given, but can't get through. Please advise. I think the question is, how do I contact the people to clarify? If you allow me to answer this, if you go onto our website, in terms of TERS, we have provided contact details for nearly every event on what you need to do. And I think this will fall in one of those. So if you go to where we speak about TERS, you will have contacts. Jackie, do you want to add something there?
No, absolutely, that's the right thing to do.
Thank you. All untrained personnel in South Africa, including security guards, are taking temperatures of patients. What is the legal standpoint vis-a-vis HPCA's regulation? I don't know if you're able to answer this, Jackie.
I won't be able to. I don't have knowledge of the HPCA, so I can't answer.
Yeah.
But it has been quite funny to see how many nurses we have.
Yeah. My sense is if the person has been trained to use the instrument, and this is a one-item detection which does not require them to do any diagnosis, all they say is you have a temperature of 38 or less, and then there's a particular process in that place that tells you what you need to do. I don't think it's a problem as long as they're trying to do. They're not making a diagnosis. So I don't think this is an HPCSA thing. The diagnosis is made after. Remember, having the temperature of 38 does not necessarily mean you've got COVID. It just means that you're on the high risk of being positive with COVID. Hi, is there a COVID-19 practice plan layout on the SADA website? I've taken a note of this. We will actually get one that you can just download and quickly update or customized for your practice? Thank you for that question. TERS have not paid out for May as yet. When when can we be expecting payment? I don't know if Jackie, you're able to
They have not updated me. They usually pay out within the first week. Yeah, so I think
Jackie won't be able to say this, but hopefully things will get better than in the previous time. It was a little bit delayed, so hopefully it will get better. We don't have answers directly to that. If we did not work at all during April lockdown, do we need to pay the staff?
If they were put on any type of leave, if you put them on special leave, on annual leave, it's difficult to go back and not pay someone. If they, what agreement did you have in place? You can't now try and get that salary back from them unless you go back and you try to claim TERS for that period because you did not work. So prove loss of income for then and then claim. And if you had paid them already, you can do a retribution with them, a recon with them, if that makes sense.
Yeah, thank you, Jackie. This one is a repeat of the one on non-healthcare people using thermometers. I'm going to skip that. If my employee comes from a high-risk area and I consider her to be a risk to myself, my staff, and patient, and has provided a recent doctor certificate that she has had pleurisy, I have been paying her although she has been off work. Do I get her suspended for the time being? So, yeah.
Well, at the moment, all areas are high risk. It's very difficult to isolate, and one must be very careful of being discriminatory on that. If you don't feel like you need her at the moment, obviously you can institute temporary layoff, especially if she does not want to come to work due to her comorbidity. If she feels like she does want to come to work and it is your choice not to have her come in, you have to continue paying her unless you give her a temporary layoff, but you have to have sufficient reason on why you do that.
All right. As a provisional earner, does the sole prop service provider qualify for TERS?
Yes, you do, because you have also had a loss of income. And remember, it's the employer and employee scheme fund. So it caters for any professional that has had a loss of income.
Thank you. If a staff member's husband and kids were in contact with the parent of a COVID daughter, I suppose COVID positive daughter, should the employee go for a test? Am I allowed to ask them all to go for a test just in case they are carriers of her? And this, to me, just out of caution. That is, can it be forced upon them after 3 to 5 days incubation period and not wait for the 14 days as the business can't be closed that long? Did you get that question?
Staff members, husband and kids. Okay. You can ask her, you can force your employees to go for a test. You unfortunately can't force anyone else to go for a test. I suppose this is again something of communication. I don't see any reason why they would refuse to do it. So you can't unfortunately force anyone not in your employ. So if she goes for a test, obviously, as I understand what you mean, you still have to wait for the incubation period. So ask her and try to make her understand why it's important. All
right, we just about. Jackie, do you have another 5 minutes? Can I add 5 few? Yeah, all right, let's carry on for a bit. Is it okay, Dr. Mbuyane says, is it okay to give staff member a 1 month's notice to an employee who has worked for less than a year if you are unable to work during COVID-19? Afterwards, if the practice is closed, what other payments are due for such employee, e.g. UIF?
Okay, is it okay for a staff member? 1 month. Yes, it's okay to give 1 month notice. All you are going to have to pay out, I'm assuming you are closing down the practice. Am I understanding it correct?
That's correct. That's correct.
Okay. So obviously any entitlements that they would have is leave that is still paid out due to them. And that's basically it.
Yeah, and of course you would then have to assist them if they belong to a medical, to a pension fund, provident fund, whatever those other.
That will be moved or be for their own contribution.
Yes, yes, yes. Thank you. As a staff member of an academic institution with a comorbidity of diabetes, my condition is under control. Will I need to inform my employer about my condition, I suppose?
Yeah, technically you have to. I think it still stays in your, it's your choice whether you do, because you are carrying the risk. You are not posing a greater risk to the employer. So if you are comfortable for them not to take any extra safety precautions for you, then I'd say there's no need to.
Yeah. After June tariff period, if my staff are on a 50% salary cut for a few months, e.g. August and September, can they claim the balance of their salary from the normal UIF fund?
Yes, they may.
Thank you. It is recommended that any patient coming to the practice leave their belongings like cell phones, watches, jewelry, rings, earrings, laptops, etc. outside the premises.
I think that would be better for you, Casey, as I understand from your protocols, that is advisable.
Absolutely. I was going to say, absolutely. Anything that's got a surface, if they can reduce the number of things that they bring inside the practice, that will be a good precautionary measure. And you should try and insist on that. And just also remember, it is always best to keep your patients, if possible, waiting in their vehicles and call them in one by one. If you follow the protocol, we've got some quite good advice there. If we work full-time, may we still claim TERS? I suppose this question should be, if we work full-time and we get paid less than our salary, can we claim TERS? Because if you work full-time, you're getting paid a full salary, you cannot claim. Am I correct?
Yes, but if you have any loss of income, if your income has changed in any way, then you can claim for TERS.
Absolutely, absolutely. If the dentist who is the key income generator and the employer has a comorbidity, is it reasonable for income protection to be denied to the individual, considering that the law wishes employers to protect workers with comorbidities? How does the law uphold this contradiction? So this question, let me just clarify the way I understand it. It refers to insurance companies who would have refused to make payment to dentists that are not able to work for other reasons, including the comorbidity. So the question is that...
I think there's a lot of contradictions at the moment because the regulations are happening so fast. So this one about comorbidities and being allowed to work only came out on Friday the 4th. It would be interesting to take that regulation to the insurance company and see what their response is in light of that.
The next question is, the next question has been answered already. I'm going to skip. Dr. Metsing, how can a patient or staff member prove that we have dealt with this question as well? I'm going to skip. Any help claims for employees? I'm not so sure. Dr. Kutsie, Dr. Kutsie, can you please retype this question, or please contact me directly after the after this, and we can try and assist you. I'm not so sure I get the question. If you work in a group of practice and one of the dentists tests positive, requiring all staff members and doctors to be tested as well, and this test negative, who is liable for payments for cost of the test? The employee themselves, or does the group practice pay for this? In other words, the employer.
Again, there's no onus on the employer to pay for it. But if it was at your behest, if you requested it and you forced them to do, then I would advise that it is for your account.
So if they
it's not explicitly stated in law, though, in the regulations.
Okay. So basically, if the employer requests that this be done for amongst his employees,
account,
it may be reasonable. Yeah. What is an example of a justifiable fear or to come to work?
I would say it is where the practice is not following any safety precautions. So that would be a justifiable fear because they have done nothing to limit your contact of or contraction of COVID. If you have a comorbidity and they have done nothing to help you, I suspect that public transport might be used in that as well. Remember, this came out on June. There has been no cases or no interpretation of it. I mean, on Friday, so it's still very new. I would think that public transport could be a justifiable fear. It's going to be interesting to see what holds up.
Okay. If I got help from SAFT who paid into the staff's account, do I only pay the balance of the salary, and do we calculate their tax on the full salary or just the part that I paid?
Obviously, just on their earning, whatever they earn, tax has to be worked out on. So, yeah, it would be on their total earning.
Okay. The second question we have dealt with, let me just say, if in any way your ability to earn as a practice has been affected and you pay people less, yes, you can claim from TARS. We have answered this question. I have 2 foreign staff. They have contributed to you. They have contributed to UIF yet. Is that maybe they have not contributed?
UIF is open to foreigners at the moment.
Okay, thank you. I'm not quite sure what the question is. The only thing that I would say to this member is that please make sure that you have followed all the due process to employ a foreign staff in South Africa. That would be my caution there. Very eloquent and informative presentation. Keep them coming. Thank you, Jackie. There. If an employee deserted employment just before COVID-19 and he is coming back demanding to be assisted with the application for assistance for the benefit, what must one do? Does a person who deserted employment qualify for UIF?
Yes, they do, because they contributed to UIF while they were employed. So technically they are, you know, they can claim UIF. If you don't want to assist them, they can now claim it themselves. So you don't have to assist them in any way if you don't want to. Because they're employed.
Do I as a dentist claim from TERS? I think we have dealt with this issue, whether it is you as the employer or it's about your staff. If you have been impacted and you've got the reduced earning, yes, you can claim. Okay. Can you deny annual increase and bonuses with the situation of limited working and number of patients?
Absolutely. Again, remember, it depends on your employment contract, but usually annual increases is not a condition of the Basic Conditions of Employment Act. So it's usually discretionary unless you have written it in some weird way in your contract. It remains at your decision as the employer. So you can cancel that. I would suggest just giving fair notice to your employees that you are canceling that and bonuses.
When we were in lockdown, we had closed and not taken the staff leave into consideration. So can the time of lockdown be taken from their leave?
You're going to have a lot of upset staff. If it was, you can probably agree with them that that is the best thing to do and that it was such a crazy time, so decisions had to be made very quickly and come to an agreement with them. Technically, you can't ever go back and take annual leave if it wasn't agreed to be annual leave. So by law, no, but by negotiation, possibly.
Yeah, I think the principle is retrospective decisions or actions, particularly if they do not benefit the employee, unless if negotiated, will normally be frowned upon. This webinar has lightened me up greatly. Thank you very much. This is from Dr. Nagtegaal. Thank you so much again to Jackie for coming to be with us this evening. I have 2 foreign staff. They have contributed to UIF yet. They did not get any relief from TERS. Jackie cannot answer this, but if they, like I hear you, I think it's a follow-up question. If they've contributed, like Jackie said, and you have followed the due process, if it has not been rejected, it is still coming your way. Am I correct, Jackie?
Yes, I mean, they would have rejected it if there was some error to it.
Yeah.
But technically, there's no reason why not.
Yeah. Why are dentists trying to justify that it can't be proven where patients get COVID? Rather, just take the correct precautions. Absolutely, that's what we've been saying. Focus on doing what is right. The others, it's not really your issue. As long as you can prove that you've done the right thing. Why can't it be criminal? Why can't it be a criminal claim if it was obvious that the practice did not take necessary precaution? Again, if it can be shown, I think Jackie will say this, if it can be shown that you've been negligent, then it's going to be problematic for that particular practice. Jackie?
Yeah, absolutely. It's only a criminal claim when you yourself have COVID, or one of your staff members have COVID and you know they have COVID and you expose your patients to it. Then it is a criminal claim, and they've regulated it as attempted murder. Otherwise, it is a civil claim because someone might still contract COVID, but you did not know that anyone had COVID in your practice. So they can still institute a civil claim in that instance because your measures weren't up to scratch and you didn't follow anything.
Okay.
Yeah.
I'm not sure if you will answer this, but let's hear. Do I understand correctly, if a receptionist is COVID positive and I, the doctor, test myself and my dental assistant, and we are negative and the surgery is sterilized from top to bottom, can we continue practicing?
The law says technically yes.
Thank you. Can we keep the practice open full hours as per normal days? Can we apply for TERS? The first question, yes, you can if you have enough patients. TERS only if you are impacted in terms of your earnings. If you are no longer getting what you used to get, whether it's your salary or for yourself, the salary for anyone that works there, you can apply to TERS. Can health workers in state employ claim that they are afraid to go back to work and enjoy the same consideration from the employer? Jackie?
Yes, absolutely. I mean, the regulation applies to all workers. So, yes, you may. I'll wish you luck.
Thank you. Yeah. Dr. Anonymous, thank you. Very informative. Thank you, Casey. So, Jackie, I get all the accolades because of you. Thank you, Doc. Thank you, Doc, there. Prof. Gilman, excellent. Pithy and important lecture. Well done to the advocate. Yes, thank you so much, Prof. Guest. We call him Prof. Guest, and I'm glad to see you online, Prof. Guest, tonight. Dr. Borat again, I no longer pay code 8109 to my locums due to PPE cost, which I used to, and I'm obliged to do so. I'm not so sure what is the question, Doc, but maybe let me say, and I'm going to be releasing another communication tomorrow. We're still negotiating with various medical aid scheme. I've got some answers, but we're waiting for them to start announcing this week. If you are charging PPE, please speak to the medical aid, ask them whether they will accept 8109 or accept 9099. Because, for instance, Discovery does not accept 9099, but 8109 they may accept. So not quite sure what the question is, but you can contact me directly and we can deal with that one. Can the doctor claim for loss of income? Yes, we've answered this again. To recoup income loss during COVID-19 or lockdown, my employer has recently asked our doctors and support staff to work from 7 a.m. to 6 p.m. Monday to Friday, as well as Saturdays from 7 a.m. to 1 p.m. He also wants us to work every public holiday for the rest of the year, but doesn't want to pay overtime. How can we approach this and what are we to do? Jackie?
That seems quite unfair. No one can force you to do these things. So if you can't come to an agreement between them and he does force it, I would advise you to take it to the CCMA for arbitration.
Are you saying that the dentist can claim for TERS for themselves as well and not just for the staff? And the answer is yes. Guys, if you used to get a salary, some sort of a salary from your practice, and you cannot now pay yourself that salary, which was on a regular basis or monthly basis, if you cannot, you absolutely can.
Just remember the maximum that you can get out is 6,700 and a few rand.
Thank you, Jackie. Thanks for a brilliant lecture. So much valuable information. Thank you. Do you know who just said that? Dr.
No.
Glackman.
Ah, my lovely husband.
I'm glad, Dr. Glackman, I'm glad you are listening to your wife.
I listen to all this.
There we go. Can dentist employees claim for loss of income during lockdown? The practice was closed or reduced turnover. So this is different, Jackie. Now they're talking about not the income of the practice, not salaries.
Yeah, there is a lot of that would not be toast. You'll have to look at all the other business rescue funds that have also been put up. So there are a lot of options that you can claim for loss of income as a practice.
Yes, but in terms of the income to yourself, that's they call it the salary portion of the income. Yeah, for the salary portion of the income, you can claim. The dentist and the employees can claim. Thank you for a great lecture coming from Dr. Bezedon. Thank you. Dr. Osman, want to thank the presenter for a wonderful presentation. I'm sure we can add this to a Q&A section on our website article in the SADJ. Yes, Dr. Osman is our vice chairperson. Dr. Martin Douglas, yeah, good to see you again there, Doc. Not maybe labor related. What about business interruption insurance? Now, I'm not quite sure if you can answer this, Jackie, but let me hear if you want to contribute.
It depends on the insurance. I've noted that there's quite a discrepancy between some insurance places. Some people are covering it as, and some have explicitly excluded it. So it depends on your provider. Your best advice here is to contact your insurance provider or who you have insurance with to clarify their policy wording.
Thank you. I think the answer is yes to the next question. I'm in a practice where one of the dentists does not want to comply with the SADA guidelines and makes up his own ideas. If we had to contract COVID where his measures are not up to scratch, could he be liable? And I think the answer is simply yes. Dr. Douglas again, great informative meetings. What does Jackie charge for consultation per hour? I will answer for her. She cannot disclose it online, but there is information that is available on the presentation. To contact her, you're most welcome. Send an email, discuss your needs, and she will, and just mention your name, she will give you a good rate. Okay, can you go back to claim from April for TERS for the doctor? In other words, those who have not claimed, can they go and claim retrospectively, Jackie?
Yes. Yes.
The answer is yes. If a staff member and family is not by the means, go for tests privately and have been in contact with a family that has COVID. They are fearful to go to public hospitals as they fear they will get COVID at hospital. Can we force them to go for the test to get it before 14 days?
Again, you can force your own employer to go for a test. You can't force anyone else to go for a test. So
thank you, Doctor.
I would just quickly suggest something to go back to the practice plan. A good advice is to do some pre-planning and put all the testing centers, because there's great testing centers that are not in public hospitals as well. Just make a list of all the testing centers around your area and where your staff stay so that it's easily available when you need it.
Thank you. Dr. Singh says, thank you so much. Dr. Osman, does the dentist who claim needs to be a UIF contributor before the period of lockdown? Jackie?
Yes, you have to be a contributor unless you can show fault of why for some reason you were not. So I would assume now as the doctor, if you did not contribute to the UIF, you would not be able to claim. If it is for your staff members or you are employed with someone else and they did not register you, then you can still apply for it.
So basically what you're saying, if I was the employer dentist and did not contribute for myself to UIF, I contributed to the employees, I can't, but I can do for my staff if I've contributed.
Yes, and if you never contributed for your staff can still claim because it's not their fault that you didn't register them for UIF.
Yeah. So I think it's a very good rider on everything that we have said. if you are not a contributor to UIF, you cannot claim. Am I correct, Jackie?
Yes, unless it was by the fault of someone.
Of somebody else, yes. Got it. Oh, I may have clicked on a question quickly. Let me just quickly go back to the last question. I think I went so fast there. Okay, it says, Dr. Schultz, if I claim as an employer for loss of income, do I use my employee's salary that I paid as a claim? Jackie, do you get that? So,
no, I'm not with you.
Yeah, I think the doctor here, the way I see the question is that he does not pay himself a particular standard salary. So what does he use to claim for such funds? But then it will also tell me that this doctor has not been contributing towards UIF as well.
Yes.
So he cannot claim.
So he would have better success in going for any business fund to claim as a business.
Yeah. Dr. Gilman, we are now up plus half an hour and over. Surely it is time to end. Other questions can be answered. Dr. Dlack, yes, I see they're adding more questions. Just allow me 2 more questions. Someone has given me information on 9099. I'm going to deal with that. And great session. This one question I wanted to take before we close. Is the application for dentists for TERS the same as that of the employee? The answer is yes, as long as you've been paying UIF. Thanks, Jackie. Last question I'm going to take. I used to pay my locums dentist code 8109. Due to the huge cost, okay, that was a question that was, we didn't understand. Due to the cost of PPE, I can no longer pay the code over to them. Am I by law obliged to pay 8109 over to them? So this is just a code that is used for a particular procedure. Jackie?
I'm not following. Just ask me again. So I can't see the question in front of me.
Yeah. I think what is happening is for every, as you would know, for every procedure, there's a code. So I think the agreement between the doctor here and his dentist, his locum dentist, was that he was going to pay them 8109, whether in full or not, I don't know. But now we've got an added cost, which is PPE, which is currently not covered by the schemes. And because of the fact that there's huge cost there, he's no longer paying them this particular code, and maybe he pays the other codes. So he's asking, is he still obliged to pay 8109 where he's no longer making money?
I would not be able to advise you on that without understanding the terms of the agreement that you have in place with him. Yeah.
I think, Doc, there, yes, we need to see what you have agreed in writing. If it's in the contract, it gives, because of the extra cost, it gives you an opportunity to negotiate with those locum dentists to say, look, my situation has changed. I would like to change this particular clause, and you have an agreement. And if you have an agreement, absolutely, you're not obliged to pay. But if it's in the contract, without a new agreement and discussion, in my mind, you are still obliged to pay that.
Yeah.
Okay. Guys, I'm going to finish this off here. We were at 11 questions left. Now there's 20 questions. Unfortunately, we cannot go further. I want to say thank you so much to Jackie for coming to spend time with us. And thank you very much to Dr. Dlackman for allowing you to be with us. I'm sure we've taken much of your evening time. I want to thank all of the people that joined us tonight. And I think I can also say it was a very informative lecture. Jackie's details are available on the presentation. The presentation will also be available on the website. Should you wish to chat to her, Jackie, you don't mind if they phone you and ask for consultations, obviously at a fee?
I don't. I work in a different way, but please email me. I'm happy to share my knowledge and assist in any way that I can. Okay, so my email is on the screen, and it was a pleasure to be with you, Casey. Thank you so much for having me, and I'm glad that it was of some value to some people. Thank you so much.
Any questions? I'm going to look at the questions that are left. If they are critical, we are going to create a Q&A, and Jackie can assist us where she needs to, and it will be posted together at a later stage.
please send everything to me and I'll answer it for you.
Thank you very much. Thank you very much, everyone, and good night.
Thank you. Okay, bye.
Thank you. Good night, everyone.